Okay, good morning, good afternoon, good evening from wherever you're watching us. You're welcome to another interesting session of the mediation series. And for the benefit of those joining us for the first time, this is not a training. Essentially, what we try to do here is to just have discussions on contemporary issues surrounding mediation. And every Saturday, what we try to do is to bring seasoned mediators from all around the world to hear their perspective on issues on mediation. Okay, Barrister says he can't hear me. Abby, can you hear me loud and clear? Abby, can you hear me? Oh, I'm sorry, can anyone
Yes,
hear me?
Yes, I can. Can you hear me?
Okay, yeah, I can hear you
I
loud
can
and clear.
hear you.
Okay, great. So essentially what we try to do here is just to discuss issues on mediation. Every week we bring seasoned lawyers, we bring mediators, and sometimes end users to just discuss issues on mediation. But today we're doing something a bit different. We're having what's called an open house discussion where everybody is on the hot seat. So just a regular conversation to find out experiences mediators have had mediating, both on the part of the end users and on the part of mediation, on the part of mediators themselves, and just a random discussion, know what their perspective on resolving dispute generally is. And of course, this is both by Fortefa Mediation Academy. It's a bespoke mediation academy where we train people on the business and practice of mediation. Now, unlike some organizations, we don't certify people to become mediators. We go right to most times we deal with the end users and we equip people generally with the requisite skills of resolving disputes amicably. What I like to fondly call IKEA mediation. So, because we believe disputes are bound everywhere. So we have had cases where some people are interested in resolving disputes, but not necessarily wanting to become mediators. So that's essentially what we do. So we teach end users the basic skills of resolving disputes. We teach mediators how to set up successful practices in mediation. That's basically all we try to do. So we'll get right on to it, Abby. Abby, so how do we proceed? How do we start this off?
I think we should have someone pick a topic just to get the ball rolling.
More like having someone, I think we should just have a conversation with Elena and find out whether she's a lawyer, a mediator,
Okay.
generally what she does. So Elena, please, can you please unmute yourself? Let's get to meet you better. And we know what you do. Is she here?
I think she ran away.
Okay.
Or maybe she's reconnecting.
Okay. Or maybe we can just, okay, and if you have any feedback, comment or questions on any on contemporary issues you want us to discuss about, please just put it here in the comment section and then we'll take it up from there. Yeah, so like today is just an open house. We're not having anything too serious. Yeah, or should, yes. Okay, Mr. Shikaye, please would you grant us, can we have a conversation with you on your experience as a mediator thus far? And let's hope she answers the questions.
Hello, everyone.
Hey.
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 As you all know, I like to be a bystander.
Yes, that was why I used the word hope.
But I want to commend Fola and Abby. You're doing a good job. I've actually learned a lot from you in the last 2-3 hot seat discussions. I must admit that I have not really been very active in my mediation practice in the last few months because I've taken an international appointment, which takes a lot of my time.
Congratulations.
Congratulations.
I was just reappointed or re-elected as a member of the ICC court for another term of 3 years.
Wow. Congratulations.
So I'm doing more of arbitration work these days than mediation. So that said, I think mediation really, for me, is the way to go, because it's quicker for me than any, I mean, in resolving disputes, it's quicker than any other method of ADR, you know, and of course, I enjoy particularly the interaction with the parties. That's one thing for me, the fact that the parties are able to take part in the resolution of their disputes. It's up to them. In arbitration, it's not that way. Of course, in the courts, it's not that way. So that interaction for me, because at the end of the day, if they reach a settlement, they know that it is their will, it is their wish, and they can't be forced to do that. The only thing that bothers me to some extent is the fact that a lot of people still find it difficult to key into this mediation thing because of their perception that the terms are not enforceable. Even where you try to explain that you can take the terms of settlement to a court, it can be admitted as consent judgment of the court, they still find that process a bit difficult to accept. And I think that's why we have that hesitation of people actually going into mediation. So for me, I mean, although I'm an arbitrator as well, I still find that it's the easier way to go. I think we just need to be able to convince people that it's not a time-wasting venture. It's not, it's not just signing the terms of settlement. The terms of settlement are enforceable. Okay, and then a lot of people also ask me how they can go about mediation without mediation clause in the agreement. It's quite simple, because you'll be surprised to know that a lot of people don't go that route because they feel that there's no mediation clause in their agreement. I mean, I did an arbitration once at the LMDC where the parties actually preferred to go the way of mediation. And they were surprised to know that all they had to do was to sign a submission agreement that they would like to submit themselves to mediation. And although they did go the route of mediation, they didn't settle, but at least they had that knowledge that regardless of whether you have a mediation clause in an agreement, parties, if they agree, can actually submit and go to mediation, because they put an arbitration clause in there because they didn't know better.
Answer.
You know, so I'd like to know other people's experience with these kinds of scenarios.
Okay, thank you so much, Mr. Shikaya. But before we go any further, as a seasoned arbitrator, I would like to hear your thoughts on this. Now, arbitration seems to be the closest thing people have. No. Arbitration seems to be that means of dispute resolution that shares a lot of similarities with litigation. Now, but then again, one thing that puts people off arbitration is the expensive nature of arbitration. So I would want to ask, what makes arbitration expensive? Or rather, why is arbitration expensive?
Well, that's a very good question. And unfortunately for a lot of people, they don't bother to, make inquiries about the cost of arbitration. Right now, I'm a member of the committee of the Chartered Institute of Arbitrators Nigerian branch. We're trying to review the fees for arbitration. Now, to make it more affordable, for the same reason why you have brought up this question, that a lot of people think it's expensive. Now, what I would say is that arbitration can be cheaper. And especially for our terrain in Nigeria, we are forever negotiating fees with the parties. Because of course, arbitrators would rather take a brief in arbitration and reduce their fees than to just let the parties go because they feel it's too expensive. I've been, in the last 1 month, I have gone from a fee of 25 million naira to 7 million naira because the parties simply could not afford it. But the rate of calculation of arbitrators' fees is based on the claim of the parties. And even where the respondent has a counterclaim, the counterclaim is added onto the claim. And then depending on whether you're going institutional arbitration or ad hoc arbitration, you come about it. If it's an institution, they have their scale of fees. For the ICC, for instance, or for the LCIA or the AAA, is either they go hourly rates or they go a percentage of the claim and the counterclaim. That's how they arrive at their fees. For institutional arbitrations, for international arbitration, is unfortunately is not negotiable. Once they calculate the percentage of the claim and the counterclaim, that is what the arbitrators will get. And then they will now ask parties to pay for expenses, because the institution will get you an arbitrator, they will have different expenses that they will have to go through. So that one is usually expensive. But if it is ad hoc, for instance, the chartered institute arbitrators, if you have a dispute to go to the institute and all that, they get you an arbitrator. If, for instance, your claim and counterclaim is about 500 million, you'll probably say, oh, they have a scale of fees, but I'm going to use an example of 5%. The arbitrator's fees will be 5% of 500 million. Now you can negotiate that because it is ad hoc. Because the fees go to the arbitrator, you can say to the arbitrator, our budget for this, blah, 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 is this. Can you take, you can negotiate with the arbitrator. So in that instance, it becomes cheaper than, what you actually thought it could be. Now, I've done an arbitration where the fee for the arbitration was just 500,000 naira. I've also been a registrar where the fee was 2 million naira. So you have different institutions where your shoe would fit. For instance, the LCIA and the Chartered Institute are trying to do this MSME scheme where the fees are so little that anybody can go there and have their disputes resolved, whether by mediation or whether by arbitration. So to answer your question, depending on where you go, arbitration really doesn't have to be as expensive as we think it is. But if it's international arbitration, you can bet that, of course, it's going to be much more expensive.
Thank you so much. One more question before I let you go, Mr. Chair. Now, the founding fathers of mediation, or let's put it that way, will tell you that the reason why the probably came up with mediation is because it happens to be an amicable way of resolving disputes. It's cheaper, it's flexible, it's voluntary, and all of that. Now, what is the true the mindset or the true intent of arbitration really? What arbitration coming to fore? What was the essence? What was it trying to resolve? Was there a problem arbitration came to solve, or it just developed or evolved naturally? Because it seems to share a lot of striking similarities with litigation. So the founding fathers of arbitration, what did they have in mind by leaving litigation to now set up arbitration?
Well, to my mind, I think that there are two things that make arbitration much more preferable to the court system. That's for me, and I think that that's what the founding fathers really thought about. Number one, time. You'll be surprised that not only in Nigeria, in many parts of the world, the court system is not very fast. So for an arbitration, max 1 year, you're done, right? And hardly do you have any appeals and things like that. For instance, in Nigeria, you go to court, minimum 5 years, then you go to the Court of Appeal, God knows how many years, and then you go to the Supreme Court. I was surprised to find out that in India, it's even worse than Nigeria. So if you can have a system of ADR where you can get your matter resolved or decided within a year, and you have another one that will take 5, 10, 20 years, of course, you would go the way of arbitration, even if you have to pay a little bit more. So time, I would say, is one. Two, the privacy. You understand? There are a lot of companies that don't want their matters out there. You understand? The court system, the registry is there. You can go pick up any information that you want. For a lot of companies or even individuals, a lot of their business is private. They don't want it all out there. So the privacy and all that, I think, is one of the reasons why people would rather go arbitration, because it's only the parties, their counsel, and the arbitrator. In fact, if you need to bring in a registrar or any other person, you have to get the permission of the parties. You understand? So that time and the privacy, I think, are the main for me, even if it will cost more, and then for some people to resolve a dispute within a year or to have it within 20 years, sometimes they see it as justice denied. If you ain't going to get justice until another 5, 10, 20 years, then at the end of the day, justice has not been served. So they rather go the route of a method of ADR that will give them what they want than go the court route. That's my own take.
Yeah, thank you so much for this. WebDoc, please, can you unmute yourself? WebDoc is another seasoned arbitrator we have in the building. I don't know whether you would want to share an insight into what Mr. Oshikaya has said for the benefit of mediators and end users in the building.
Well, I think what aligned with
we can barely hear you, WebDoc.
I pretty much align with most of what Ms. Oshikaya said. Arbitration is civil justice done privately. And if you think arbitration is expensive, then I think you should consider civil justice, because for the kind of issues that we resolve in arbitration, there are issues that are too complex for mediation, and yet they don't want to go through the route of the court because they need an adjudicative decision. So you find that the flexibility of arbitration helps parties bring their high value dispute. We're talking of $5 million, $100 million. I mean, within this COVID, we've had close to $10 billion worth of vaccine disputes disposed of within 30 days. These are issues of copyright, IP. This can never happen in civil justice. And so the arbitrator has to sit down, read the papers, take a decision, and then write an enforceable award. So that's what arbitration is. It's just civil justice on steroids. And you have to pay for the steroids.
I like that.
So basically, nobody is forcing anybody to go to arbitration. The civil court is always there. Parties can vacate their agreement and go to court. But when you want to come to arbitration, you need to be ready to pay for it. Now, what are you paying for? You're paying for the time, you're paying for the expertise, you're paying for the confidentiality, like Mr. said. You're also paying for the enforceability of the award. A court judgment, is restricted to that jurisdiction. Under the A rules, you can take it overseas. You know how complex that is. But with an arbitration award, you can take it to every country that is a signatory to the convention, which at this point in time is almost every country in the world. Iran is on now, Pakistan is on, China is on. So everybody knows that for the portability of award, you can port your award from Lagos. I did an award a few years back for a property in South Africa. It started in Lagos, I wrote my award, the council went to South Africa, got the property auctioned, and came back with his money in less than 60 days.
Okay, WebDoc. Yeah,
yes.
if I may interject. Now, looking at arbitration and using Nigeria as a case study. Yep. Now, the things I say, talking about arbitration and using Nigeria as a case study. Now, we heard these things about arbitration awards being contested in court, which ought not to be so. We started hearing of arbitration cases now staying so long in court that at the end of the day, the concept of confidentiality, which should also be one of the bedrocks of arbitration, once it gets to the open court, would now be open. And how lawyers are now, one way or the other, turning arbitration into litigation. Now, I'm an outsider, so I'm just speaking based on the things I hear and all of that. So I would like you to confirm if some of these problems are inherent in arbitration and the steps being taken to avoid such issues. Because apart from the expense, which Mrs. Oshikaya has explained, the issue of the delay and everything litigation, everything arbitration was supposed to try to avoid is what is really happening now. So I'd like to hear your thoughts on this.
Very well, thank you very much. I think that the civil justice procedural rules are basically aligned to support arbitration and make Nigeria a very good state. When you challenge an award, challenge is based on a very short window. based on Section 29 of the Arbitration Act, misconduct, overreaching mandates, etc. Very, very short window, mainly procedural, nothing on the merits. Now, when you bring that application, in most jurisdictions, you have to redact the award. So you say Party A is alleged award versus Party B before Honorable Tribunal B. You don't put any names in it. In Nigeria, I'm not sure that that is enforced. But now, it's now going to come online so that confidentiality is maintained. Two, people have to basically honor their agreements. You know, I think a respondent who has not paid for the application and the payment has borne all the costs is one who will go and sit down and challenge the award. But many times, it's really shooting yourself in the foot. Because when I give an award, I give mainly 30 days to 60 days, and I give a very high punitive interest rate. So you can challenge the award for the next 10 years. That is running. So except you're going to wind up or go bankrupt, you're going to pay for every delay you're bringing on. So counsel need to learn that when you submit to arbitration, it's a final and binding decision. There's no need to challenge it, except where there is clear procedural errors. And we are having these cases coming up now, disclosure, Ali Button and Chubb. We're having in Nigeria, we had the case of the Chevron, and we have a few cases where judges are becoming activists, telling you that if you chose your forum, stick to it. So I think that problem is, as far as I'm concerned, in the last few years, it's been eradicated. It will take only a very unknowledgeable counsel now to use a very, very careful word, go and start set-aside proceedings. Just like the Court of Appeal is making it difficult for you to bring frivolous appeals, and the Supreme Court is mainly becoming almost futile to challenge awards now. The decisions of the court have spoken clearly that you must think or swim with your arbitrator. Now, just to quickly talk about cost, so I don't forget. Many times we talk about cost in arbitration, we're talking of ad valorem cost. When you're talking about a percentage of the amount in dispute. Fola, you can ask the arbitrator to charge you per hour and agree on an hourly rate. You can also ask the arbitrator to bifurcate the matter. So if, for instance, party says, we will go and mediate liability. And when we have gotten liability, we'll come back to the tribunal to help us look at quantum. Or the tribunal should just help us determine liability. We'll go and determine quantum. More reasonable. We'll give the tribunal decision, let's write an award for us on liability, who is liable, and then leave us to go and mediate. So it saves cost. So I'm not going to have a complex decision calculating quantum and all of that. I'll just simply look at the contract, interpret it, and give an award. I will charge you something simple for that. But the Act said, 49, on fees, that the fee will be reasonable and in consideration of the amount in dispute, the complexity, the nature. So it's not only based on amount in dispute. There's a plethora of conditions set out in the Act on which the fees are based, and on which the institute bases the fee. So if you reduce your complexity, reduce your amount, reduce your timing and all of that, you get a favorable fee. I think it's really counsel has not been knowledgeable. Who just come and dump general damages, special damages, punitive damages before the tribunal, 1 billion, 3 billion, and they want to pay for cook and drink champagne. So it doesn't work.
Yeah.
I don't know if I can. Sorry,
okay.
I don't know if I can interject. My name is Nena Uko.
We've been looking for you.
I'm sorry, network and all that, and then I'm at a function somewhere, so also try to pull myself away from it to comment. So, but I heard my sister Ejide talk. Ejide, congratulations once again. But the issue she mentioned on cost, and the fact that arbitration is to be embraced for different reasons. I think one of the reasons we also want arbitration, apart from the fact of privacy and time, is that there's absence of hostility at the end of it. I mean, more often than not, because you're not in court wearing gloves and trying to slug it out in court. So there's that absence of hostility, which makes it a cheaper option. And then when we say arbitration is expensive, when you look at the cost of being in court for 5 years, and paying appearance fee, apart from the professional fee. If we really sit down, especially in Nigeria, where we don't look at our costs, we don't.
Sorry, Nana, I just have to cut in. I have to chip in. I see Justice Rolly Harriman. Milord, you are very welcome. Thank you so much for joining us. Sorry
So
about that. I just have to
no,
acknowledge
not
her.
at all. You're welcome, my lord. Not at all. So when you check what it costs you to be in court every day with adjournments, with strikes, and what have you, that is always in our faces in Nigeria, you find that at the end of the day, arbitration is not necessarily expensive the way we want to interpret it. And then sometimes when matters are stuck in court over an arbitration that you already have and the person is appealing it, sometimes without casting aspersion on judges at all, sometimes it could be not having a full understanding for some people, just like you have AMCON rules. When you have AMCON, with AMCON, judges are trained to be AMCON judges. You can tell the difference when you appear before a judge who has not been trained as an AMCON judge and one who has been trained as an AMCON judge. The difference is like white and black, literally. Things that you will sit on talking, the judge understands it. Yes, the judge sees ahead of us lawyers and the shenanigans that we get engaged in to delay matters, and the judge just stops it right there and then. So also with arbitration, I feel like there is need to do the same. So you don't come, a judge will clearly show you that invitation because, like, don't you know what the rules are? If it does not fall into misconduct or whatever will make you bring it before me, like there's been a procedural error in carrying out this arbitration, it should not even come before me. And then again, Court of Appeal, before you go on appeal on different matters, you're made to pay in the judgment sum. So by the time you put these things in place, you find that people who take advantage of the system or take advantage of where we are in things or understanding, it will end, or at least it will reduce to a large extent. Thank you.
Okay, thank you so very much. Abby, I want to take this discussion to another level. Is there anything you want to say? Because, Nena said something, Mr. Shekaya said something, and WebDoc said something, and a question just came to mind now. I don't know, because you're going to take this discussion radically from where we are. Is there anything you want to say before I proceed? Sorry? Can I?
Sorry, I wanted to say something, but Rev Doc had addressed it. Can you hear me?
Yeah, loud and clear.
Rev Doc had addressed my question, so go ahead.
Okay,
yeah, so I wanted to say something, but Rev Doc had addressed it. So go ahead. Okay, so I'm going to lay a premise for my question to give a bit of more context into it. And rather than coming in from the angle of mandatory mediation that I always keep hammering on, can we also, how about coming in from the angle of mediation being a condition precedent to every form of dispute resolution? Now, if we decide to look at mediation in the most simplistic of terms, you understand, an amicable resolution of disputes, and what just makes mediation, I'm just trying to be as pedestrian as possible, and what really makes mediation different from counseling, different from every form of dispute resolution is that there's a third party, thank you, assisted negotiation. Yeah, there's a third party neutral. You see, that third party neutral is really what gives that form of structure to mediation, and the fact that at the end of the day, whatever it is you have would be reduced into writing. And so if that be the case, I'm just thinking from the top of my head. Now, why can't mediation be a condition precedent to litigation that we are seeing right now, where sometimes in a court-referred matter, cases are referred to mediation. Even in arbitration, wherein maybe if parties, because someone said something, I don't know whether I'm going to quote him out of context, about some people putting arbitration clauses in an agreement as a punishment clause, when you know that the amount in question, because people can't really afford arbitration, so to say, so they always put in arbitration clauses. So from the top of my head, I'm just thinking, can't mediation just be a condition precedent? Okay, fine, this is litigation. Before we now decide to go through the rigors of litigation, let's try and see whether we can even have these issues resolved amicably. Even with arbitration too, that okay, fine, before we now decide to arbitrate, let's see whether we can have these issues resolved amicably. And one of the reasons why I always like to go down this lane really is because of the lawyers. Because at the end of the day, I'm not trying to strip
lawyers of their powers of advocacy, but to more or less even have this conversation with the people involved, the parties involved. Let the parties have this discussion and communication. So I'm now going to take that back to my question now. What are your thoughts on mediation being a condition precedent to arbitration and litigation? So, the floor is open.
So, Fola, are you saying, are we talking about mediation being mandatory?
No, mediation being a condition precedent. Now, that word mandatory sounds harsh because you see,
that's semantics.
Well, you call it semantics. Yeah, no, you call it semantics. You understand? No, why can't I use the word mandatory? Because it might work for litigation, but it may not work for arbitration. Because if people elect to go into arbitration, you cannot mandate them to use mediation. But when you say it's a condition precedent, okay, fine. Let parties let parties even try and have a conversation. You understand? Let them see whether there's an amicable way of resolving this issue before they go to the other side. Doc.
So which means we have Mr. Akisoya with us today. I would love to hear his input on that.
Today is going to be very interesting. Okay.
Salut.
Yeah,
good evening, sir.
Good evening, sir.
Salut.
Good evening, sir. Okay. So I think Doc wanted to say something. Or Abby, you want to go first before we take Doc and Mr. Kisaya?
Let's leave it open.
Yes, Doc.
So Doc.
Yes, sir.
For the last 1 month in the UK, I've been in the UK. The UK is now making the use of mediation, well, like you said, they are also not defining it, either mandatory or constitution precedent. Litigation in the UK is taking course very soon. This is one of the civil justice reforms post-COVID, and we're in a training with the Lady Justice in charge, who is one of the Court of Appeal judges, who is going to enforce that. That's now a mandate. Will be the Lord Mediator of the UK. Now, the funny thing is, the Charity of Arbitrators UK had a webinar on this. The FIDA had a webinar on this, and several other bodies had a webinar on this. I attended all of them. The mediators are up in arms. They don't want it. They say to cheapen the process, it will no longer be voluntary, and it will be total abuse of mediation as a whole. That as an option. The lawyers don't want it because they say it totally tarnishes the litigation process. The parties now go and talk the documents to the mediator under a confidential process or non-prejudice, or come back and still have to fight in court. The UK now is really confused. They've gone ahead to pass it, won't take effect, but the lawyers and the mediators are saying no, no, no. I belong to the Institute of Arbitrators and Mediators, New Zealand. New Zealand has just passed the same law last month. As of this morning, I have signed a petition which they're asking all of us to sign as members of the Institute, saying that we don't want it. Let mediation continue to remain the way it is, voluntary for parties who want to explore that amicable settlement before litigation. Don't let the processes interweave. Let them be.
Well, Doc, why are you against it? Because you wear both hats of an arbitrator and arbitrator. Because why I ask is that this does not take away the element of voluntariness. Because it's just bringing parties to the table and trying to take away that cloak of what's it called, the lawyer's interference, for want of a better way to put it. But it does not affect voluntariness. So why are you against it?
My opinion, as a mediator, also as a advocate, and also of the parties, I feel that a good mediator can conduct the process, add value to the parties, and whether they settle or not, it can leave the place better than they came in. But you see, where are the good mediators? If you don't have good enough mediators, it's going to be a total chaos. When you say parties should go after filing their pleading, go and discuss with mediators, especially remember that there's caucuses in mediation, private meetings. And sometimes mediators don't handle it properly. So I take the argument from both sides. I'm neutral, I'm watching. But I think that it is best practice. In arbitration, the CIF tells us when you have a reference, you must let the parties go and negotiate first, do a mediation before you start the arbitration. It's compulsory for good practice. I don't just rush them into arbitration. But in litigation, I think the courts also are having a multi-law court now. There are 16 now in Nigeria, also asking you to explore this. But the difference between the one in the UK is that there will be costs attached if you don't go, or if you go there and refuse to settle. Now, even the mediators report, I was surprised that mediators are now being sued in the UK. That part in your opening statement, I will not be called as a witness, and everything you discussed with me it is totally not valid. And I have about 3 mediators who have been put in the dock. We are lucky that the parties went back and settled. Otherwise, we don't know what will happen. They would have been jailed or they have been compelled. One of them refused to give evidence. He was ordered by the court. He was remanded in contempt. Luckily for the parties settled. That was the most pronounced case. I searched online. So he was a very, very experienced mediator, but he refused to give evidence, saying that there was an agreement with the parties. But the judge said that agreement is null and void, and she should give evidence in that case. So a lot of things are happening, and I think that when mediation becomes again another very complex process like arbitration, I think you just let sleeping dogs lie.
Okay, I hear you, WebDoc, but I share a different opinion. But let me hear what Mr. Kisa has to say about this. Short question: should mediation be made a condition precedent to means of resolving disputes?
Let me start off from where RevDoc was speaking, and with all due respect, I totally disagree with him. As lawyers, let's forget arbitration, let's forget mediation. As lawyers, there is something called attorney-client privilege, and it is protected. There are documents that are written by lawyers, we call it attorney work product. It cannot be subpoenaed to evidence. The courts of law respect the privilege of the mediator. And I would say to myself that I do not have sufficient facts in front of me to debate why the kind of case he was referring to happened. It is not just that it doesn't matter. The work of a mediator in presiding or in facilitating the engagement between parties is protected, it's privileged. It is, again, let me also give you another example. Parties sign confidentiality agreements, and those confidentiality agreements are binding, and courts will respect the refusal or reluctance or unwillingness of a party to produce information which is the subject of a confidentiality agreement. The only time they would overrule that is if there are issues of national security, especially bordering onto treason or terrorism or things like that. But again, confidentiality agreements will be observed. I know that as lawyers, we all know that what I'm saying is what I'll call Law 101. So with all due respect, I don't buy that. I don't buy that situation at all. If it is happening, I think it's a gross abuse of the law, and we should not allow an abuse of the law to become for us a means of setting a norm. So that's number one. Number two, I also want to say this, that there are issues around mediation which parties have had to deal with at different times. For example, when parties come to the end of a mediation, they have a settlement agreement. It's a contract. And one of the things that one has dealt with is that in writing your contract, you must be careful because a mediation agreement is also a contract, and many of the rules of contract apply to it, except that the entire process of the mediation itself is accepted as the consideration for the agreement. Therefore, they don't have to offer consideration. However, I have often mentioned that it is possible for you in a mediation agreement situation to have a party, say,
claim non est factum. And that non est factum says, what has been written down here, I do not recollect that that is what I agreed. And even then, it is not something that anybody can just go in and be telling lies about. There are rules for determining this. It wouldn't work that way. So again, I want us to not start getting nervous. Mediation is safe. Mediation has a long way to go. Mediation is a new thing. Now, number 3, I believe that I'm sure as those who've been with me, with Fola and a few others on some of the programs where I've been on, I've made one thing plain repeatedly, and that is, even as mediators, we ourselves as practitioners of mediation, we need to understand what mediation is and what it is not. Mediation is not just a compromise. It's not just a settlement. It's not just a settling of a quarrel. And that is the one thing that we have to understand. It is not just a matter of whether mediators the two parties have agreed to settle. No. One of the things that is happening with mediation, especially in Nigeria at the moment, unfortunately, especially now, is that mediators are looking at mediation as just give and take. Okay, let's settle. It's better than going to court. You can save some money. No, that's not what mediation is about. That is not mediation. That is compromise. Maybe we might even say it's to some extent conciliation. But I'll tell you this, that is not mediation. One of the things that mediation has that is very important is that, number 1, mediation is clearly not just voluntary, but it is one in which the parties themselves it is one in which parties themselves are responsible for the outcome of their matter. In every other dispute resolution process, litigation, arbitration, conciliation, one of the things that make them distinctly different from mediation is that in all of those other processes, parties have abdicated responsibility to a third party. Parties have abdicated responsibility to a third party to take the decision for them. In mediation, parties must remain responsible, and a professionally trained and efficient mediator will always work in such a way that that power never is taken away from the parties. Now, if we can get a situation where we can begin not only to practice mediation, but to also educate our constituency on mediation, it will be easy to understand. Lastly, we've tended to see mediation a lot from the point of view only of a suit in court and mediation as ADR. But one thing interested me, every time I've picked up a major book on mediation, a major title on mediation, and this, take for example C.W. Moore's book on the mediation process, you'll find that the court aspect of it, the commercial transaction aspect of it, forms only 30% of what constitutes mediation. So we mediators also must begin to think beyond just mediation as an ADR process, but as a process in itself that is applied.
Yeah, I'm sorry, sir. If I may interject, do you plan on linking this to the question I asked? about mediation being a condition, what your thoughts are on mediation being a condition precedent to litigation and or arbitration.
I believe that, let me answer it very plainly. I don't believe that either way is right or wrong, good or bad. In Lagos State already, under the civil procedural rules, the courts require that before you sue, you must have pursued mediation. But that is a court process. And it's good. If it's present, it's good. Unfortunately, as a side note, many practitioners in Lagos, in Nigeria, totally ignore it. Up to now, I'm receiving letters and cases from lawyers, and they seem not to care. I think this country is known for impunity and lawlessness, and we lawyers are the chief protagonists of it. Now, it can be a condition precedent. If it is, it's good. It is good. If it is not a condition precedent, if there are many lawyers who are mediation advocates or who are mediators, it will become a way of doing things. So what I'm saying essentially, my answer is, should it be a condition precedent? Yes. Should it be a condition precedent? No. Either which way goes for me. As far as I'm concerned, none is going. Okay, let me put it this way. Sometimes as practitioners, we're hoping that if that is done, it will help to create more work for mediators. No, not at all. Because like you've seen, people are ignoring it. So you cannot legislate mediation. Mediation is a mindset, is a culture, is an attitude. It has to be acculturized. People have to be acculturized to mediation. And mediators have to know that part of our work is not just to practice mediation, but to actively engage in the process of acculturizing our society to mediation.
But the general argument that comes up most times is that if it is made a condition precedent, it would eliminate voluntariness. Do you agree with that?
No.
Okay. Thank you so much for this, sir. Does anybody want to unmute to share the insight on this discussion thus far? Based on what,
I have something to say. Is there anyone else before I go ahead?
You can please unmute yourself if you want to. I don't think anybody has been excluded from unmuting. Okay.
Hello. Hello.
Okay. Please speak. Yeah, Mrs. Evelyn. We can hear you.
Okay. I supported the last mediator that just spoken. The issue of making it a condition process is a very good idea. But the fact remains that the lawyers are not supportive of it. The reason is that they feel that they will not get their job. That is, they will not be paid when they advise the client to submit to mediation. Because sometimes when the clients come willingly, that they want to approach mediation, they will tell them that if you like, you can take a lawyer. If you don't like, you can come on your own. So that idea sometimes it makes the lawyers to be frowned about mediation. And whenever they come, they want to talk the way they talk in litigation. So they want to speak for their client. But at the time you tell them that just let your client express his own view of the matter, we say, no. Why am I here? What's the reason? Why should I be here? If I can't say anything, there's no need. So sometimes these ideas has frustrated mediation for a very long time now, especially in our jurisdiction. It has frustrated because they just want to be fully involved the way they are in litigation. So if it's a conditional process, it will be very fine because it's voluntary. If they refer you to court, you can come. If the client is willing I think the lawyer will make it as if it's compulsory, something that you just have to approach. Let's just approach it. If it works, fine. If it doesn't work, you can proceed on your litigation. So that's what I want to say. Thank you.
Thank you so much, Mrs. Evelyn. Thank you. I see Eunice. Eunice, you want to unmute yourself, please? Thank you.
Yeah. Good evening. Good evening, everyone. Auntie Abby, good evening. Yes, I think making already in Lagos State, it appears it's a condition precedent to filing, especially in the High Court. And then one of the misconceptions that people have is that, oh, you are calling for mediation because you have a weak case. And it saddens my heart when you see people reasoning this way. But when parties know that, okay, it's just you are fulfilling the condition precedent to going to court, perhaps the level of participation will increase. So that party will know that, okay, you are not calling us because you think your case is weak or because the rules of court says I must participate in mediation. And going back to what Fola said, that will not take away the voluntariness. I don't think it takes away the voluntariness of the mediation, because coming to mediation does not mean that you must settle. Exactly. But at least you give it how will I put it? Yes, an option. It's not as if you must settle, but you explore it. That is it possible? There are some matters that the parties already made up their mind that it cannot be settled. Maybe because of principle. Some people go to court because I want to prove to set a precedent. You know, in that kind of situation. But we've seen people that even though they have principle, when they come to mediation and they hear things, they change their mind along the line. So making it a conditional precedent by the rules of court, I think we allow for more participation. Thank you.
Thank you, Eunice.
Abby, I'm sorry, but let me just lend just 1 minute to what Eunice has just said. See, let's just identify the two elephants in the room as far as the antagonistic nature of lawyers are concerned when it comes to mediation. Number one is the issue of fees. You understand?
Yes.
Number two is the lack of understanding. Now, you and I know that when it comes to mediation advocacy now, the strength of mediation in mediation advocacy is the discussion you have with your client before you get into the mediation session. You know, that is the, now you see, as simple as what I just said is, that is the basic distinction. Litigation advocacy is when you address the court. But mediation is how you prepare your client before they get into mediation. So if you ask me, two basic reasons. Number one is the lack of understanding. Number two is the fee element. It's the fee. So I'm always surprised when we're having this conversation and somehow, some way, we don't hit the nail on the head by saying what it is. Because you see, take away those two elements.
We're ignoring the cocoa of the matter.
Because the truth of the matter there is here, the only thing that can change the mindset of lawyers is when clients, you understand, start insisting on mediation. See, it's a classic case of demand and supply. When a client comes to meet you and says that, you know what, it gives you people, he said, look, I'm having issues with this person and I need that money back within X period of time. I can't be in court for 4 or 5 years. You understand? What are you going to say? Are you going? You can't recommend it. You can't recommend litigation. Secondly, they tell you that, you know what, I need my money from this person, but I have a business relationship with him. I still want to sustain that business relationship. You can't recommend litigation. So ultimately, this change that we're talking about, this change that I feel will not come from lawyers. We can try our best. We can try to educate them as much as possible. But at the end of the day,
it will come from the end users.
It will come from the end users, because it's a classic case of demand and supply. It's going to come from the end users. So for me, once we identify what the problem is, then we start looking towards the solution. And what is the solution? Really, if you ask me, it is empowering the end users of their rights, making them own their case. Because really and truly, what is mediation? It's all about facts. It's party driven. So that's the way I see it. So for me, it's the issue of the money and the lack of understanding. Nothing more, nothing less. Your thoughts, Sabi?
I agree with you, Fola, but I wanted to say something to what Eunice said, and I see Mr. Kiswaya's hand is up as well as Eunice's hand. But I just wanted to say that we have a pre-action protocol that requires that you do, you make attempts.
We have shown that is circumvented, Abby. Have you seen them?
Wait, so my point is, it's being circumvented. So the only way, when you say, okay, so there's a comment here from Remy that says, I believe for mediation to have a strong ground, we need to get someone to sponsor a bill. I would actually like Mr. Kisoya's comment on that. But my thing is, if we look at it from the way it is now, the lawyers that are supposed to be abiding by the rules, and I think Mr. Kisoya had said this earlier, the lawyers are the problem. Because you know that if this is in the rules, this is in the civil court procedure, High Court civil procedure rules, you're supposed to do X, Y, Z. Then why is it so difficult for us? So this same thing is the way we say Nigeria, we have problems. We are our own problems. So if lawyers say, you know what, if we remember the reason why we're even called, and we are actually supposed to be solving our clients' problems, as opposed to trying to become SAN or trying to enrich our pockets. And there's nothing wrong with being enriched here. But it's important you think of your client's need as, okay, I'm going to stop because I see 4 or 5 hands up. So I will take ladies first. I will take Eunice first. Eunice, can you please unmute?
Yes, thank you. I just want to buttress what Fola has said. Yes, money is part of the reason why lawyers, they want to be antagonistic to settlement, especially when it comes to property that it's on commission. So the higher you're able to negotiate, even for debt recovery, the higher you get. Then another thing, when we're talking about being efficient and effectiveness for our clients, I have had to actually file an action. Yes, I know that mediation, we're still going to settle, but working mediation is not free. So if I work in and file a statement of issue, lawyers know, they will advise the client, you don't need to submit, it's voluntary. So you can either submit, even when mediation judge call them, they won't submit. So what I advise is that, okay, let us file the action. When we file the action, it will be screened for mediation. Or sometimes you even tell the court that I believe this matter can be resolved. Please refer us to mediation. With that, what I've saved my clients is the cost of paying mediators. So we don't pay the administration fee and we don't pay the mediator's fee because it's going to be a court-referred mediation. But many people don't have this understanding. So in your fee note, you've already stated if we settle, this amount you're going to pay. If we proceed to trial, so we break down the issue, the element of fee. So it could be part of cost. Fee is definitely part of why there's people don't submit to mediation, but lawyers can become smarter and wiser. And I think we continue to educate people, to enlighten people on how to go about it. Thank you,
Eunice. Thank you. So, Mr. Kisoya, please, can you unmute yourself, sir?
I was actually going to ask that Yejide and Benjamin should go before me. I've spoken already. I think
okay.
Maybe they should go first, and then after either of Yejide or Benjamin, I could go next, and then I think that might be more democracy, more mediatory, I think.
Okay, so Yejide, would you like to go first, or we take Mr. Benjamin? I know Yejide has spoken earlier, so Mr. Benjamin, can you please unmute?
Thank you very much. The Holy Book says, teach your child the way you want him or her to go, and he will not depart from it. One of the issues here is that mediation is just becoming a new thing in our environment. Just like Mr. Kisoya said, there's a cultural thing. We need to go back to law school. You see, people need to take it from that level to start educating, just like Tolu said. You have to educate people from grassroots. Gradually build it up. That is part of the legal process. It's part of the way to achieve dispute resolution. Litigation shouldn't be the only way. Part of the ways is also mediation. Part of the way is also, so we need to do that. What the LFGC is doing right now, or Lagos State, is that to a great extent, it's even in Lagos that the great of this thing is happening. So even when you talk about Lagos, if you cross over to Badagry area, most of these things are not even known. If you cross to Ikorodu, so there's a big step that needs to be taken to get the public to be aware when it comes to the parties themselves. But then to disabuse lawyers and get them to realize that if you take on mediation, you don't lose your money. It also has to do with their thinking and training. That a client walks into your office, you first of all agree your fees. Some lawyers don't go to court. They could just be strictly a commercial person. They could just be advisory only, and they make their money. So people need to be educated that, oh, this is it. There are some lawyers that just sit down quietly and they are strictly compliance officers for a lot of organizations, and they're making a lot of money. Some people are sitting quietly in their practice. They have litigation section, but they don't even really bother too much about it. They deal more on commercial advisory, all these organizations here and there. They go into various locations. They identify. There was a time a lot of people thought making money is property, selling property and things like that. The people that are now making a lot of money from aviation, a lot of people probably don't know that there's a lot of disputes in that area. So these are the things. Falling on the hangway, for example, trying to walk down the airport somewhere. A lot of people don't know some of these things. So we need to educate people. But in my own way of cultural thing, like Mr. Akisanya said, you need to take it from the grassroots. As you train the lawyers gradually and say, look, this is part of the whole process, because a lot of lawyers don't know that. A lot of lawyers don't know that. It is when they now get to know it, during this week of settlement week, I had issues with lawyers, and I had to say, hey, I can excuse you, you understand? And you see, this matter will still go on, So, and that is it. And also the people need to be told. So the public needs to be more aware. What is happening in the Lagos environment is fantastic. But when you look at our jurisdiction, Federal Capital Territory, all these places, those states, they're not really aware of this other aspect. But lawyers, from their training in law school and all additional training, can help solve a great number of these problems. That's my contribution. Thank you.
Thank you so much, sir. Yejide, would you like to unmute?
Okay, thank you very much. I agreed with Mr. Fatogun with respect to the issue of education, but I want to hammer a little bit on the aspect of something Mrs. Roberts mentioned when she was on the hot seat, that we lawyers need to be a bit more creative, or we mediators, we need to be a bit more creative, because we keep saying that, lawyers complain because of the money, they're not well paid. But I find that if we ourselves sit down and are a bit more creative on how we can make money as mediators, then, the sky is the limit. Because when you are an arbitrator, you get a lot of money. And I think they do more or less the same kind of work, because at the end of the day, they start the case, they finish it. It's not a matter of, a mediation settles in one day, and so you can't charge as much fees as when you're an arbitrator or when you go to court. Granted, court cases take a lot longer, but we need to be charging as mediators. Of course, the way you are mediator of the courts, the fees are fixed quite all right. But when you are doing other mediations, you can charge a percentage. That's what they do in arbitration. We shouldn't cheapen what we do. Because when we start saying, oh, because we settle in 1 week or we settle in 1 day, so you shouldn't charge so much. Who says? Secondly, I think aside from the lawyers, the parties themselves are an issue. Even when they submit to mediation, how many of them come for the sessions? When they go to arbitration, they attend the sessions. When they go to the court, they attend the court sessions. But when it comes to mediation, because of their perception, and probably because they're not well educated, a lot of them don't attend. I mentioned during Mr. Shenny Williams' discussion last week that a lot of them don't even like the environment of the courts. We lawyers or we mediators need to be more creative. Take them to where, because at the end of the day, you want the matter to be resolved. Take them to where they feel comfortable and let them pay for it. And you'll be surprised that a lot of them can pay for it. If they feel that, oh, we cannot come to the LMDC, we cannot do a lot of them, I find it very irritating. I'm having a session and they have to go outside to go and call the parties. If you have submitted to mediation, then you have to step in all the way. If you know that what will settle the matter depends on you and on your decision, then why will you not be there? So all this perception of, oh, I don't have to be there, even the senior lawyers will not come, they will send one junior lawyer that was just getting the file that day. It's frustrating. And those are part of the things that actually make a lot of people not believe in the process. Because some people believe that when they go there, they're going to be meeting somebody that was called to bar yesterday. They're going to be meeting the receptionist at the company of the place instead of meeting the people that will really ensure that these disputes are resolved. So it takes a lot of education. If you're going to go to arbitration, you will go. You will not send the receptionist or the office manager. You will not send a junior counsel because you know the efforts that goes into it. A lot of people feel that the kind of effort that goes into mediation is probably not as much as, and that's my honest feeling, because I've attended mediations where at the end of the day, I had to just adjourn the matter because I wasn't going to get anything from the kind of people that were before me. Half the time they were stepping out to go and ask questions. Half of the time they were telling me that I received the file just this morning. My senior counsel had to go to court or had to go to another matter outside. I mean, this matter is important. The fact that it's a mediation does not mean it is less important than the arbitrations or than the court matters. So that's my own opinion. The lawyers have their own issues, but even the parties themselves, they have to be all in. They have to believe that they can get something out of the process. Thank you.
Thank
you. Yeah, very quickly. I just want to ask Mrs. Joshua a question. On the ratio of 1 to 100, if we were to focus attention on who to educate more, would you say the lawyers or the end users on the ratio of 1 to 10?
You see, the lawyers are well educated, if you ask my opinion. I think it's the end users, because at the end of the day, the ball is in their court. The lawyers know, initially, we all know that they didn't like it because they felt they couldn't make money out of it. A lot of us mediators now know how to make money out of it. So I don't think it's a matter of the lawyers. It's only those that do not know how to make money out of mediation that are still fighting it. And for some lawyers, once they get one court case, they see it as feeding allowance for the next 5 years. So obviously they don't want to let go of. Those are the ones that have not educated themselves on how to make money out of mediation. So it is the end users who know that they are going to be paying for these things that need to be educated. They need to know that.
Okay, so what education is there now on arbitration that isn't available for mediation?
Well, you see, the mere facts alone that the end user perceives that it is not enforceable. Once people are satisfied that mediation is enforced, for some reason they don't believe that the awards, the terms of settlement are enforceable.
So that's part of the root of the problem.
At the end of the day, they will still go back to court or they will still go back to arbitration. And that's why a lot of them don't even like to come for the sessions, because they believe it's a waste of time. That is where the education needs to be, that it is enforceable and that it can end the dispute. Once they are convinced of that, I believe that they will be all in. Because at the end of the day, what do they want? They want that dispute to be resolved in the fastest possible manner.
Okay, so I have two comments, but we'll take the participants. Mrs. Evelyn,
no,
can
Mr.
you please
Kisoya. No, Mr. Kisoya was supposed to speak.
Oh, my apologies. Yeah. Mr. Kisoya, please go ahead, sir.
First of all, no apologies necessary. We have to try to understand ourselves in these things. First of all, when we speak about power, when we speak about money from the lawyers, it's really not about money, it is power. When you are in a court of law, the parties don't have the power. The judge has the power. Next to the judge, you have the counsel. And that itself is a system of education which we have. Why arbitration works, with all due respect to my sister Ejide, is because it mimics the law court. The arbitrator or arbitrators are judges. They make awards. People like to abdicate responsibility to another party. That's why they don't like mediation. Secondly, you're right. I'm sure those of you who've attended the SCMA mediation advocates certification courses when I've taught, there is a part I've always added in, which is not in the official course, by the way, which is what I call understanding the value chain of mediation advocacy. And I've often said to lawyers that, look, everything in life has a value chain. If you talk to people who do marketing, they'll always tell you, you need to know what is your value proposition. The truth of the matter is that in mediation advocacy, there is a value chain. That value chain is unique to mediation and its advocacy. It's not the same as in litigation or even in arbitration. So in one word, when we talk of lawyers being creative, it's just another way of saying you need to find that value chain, because it is when you find that value chain that you are able to exploit it. Is when you know what is the value proposition. Now, many of us, when we talk about mediation to clients or to parties, we say it will save you going to court for 5 years. Look, there are people who will say, I don't care if I'm in court for 20 years. It will save you money. There are some people who tell you, I don't care. There was a time when there was a lot of fraud that was prevalent in a company, in a multinational. And the CEO of the company said, I'm going to stamp out this fraud in this company. I don't care if I spend $10 million to go after you for stealing $100,000. So again, you have to be, it's a matter of education. We have to know what the value proposition is. With all due respect, 99% of persons trying to practice mediation are coming into mediation with a lawyer's mentality. It won't work. That's what's failing us. And then again, another point is that the issue of acculturation is important. People need to know. There's another point that which I agree with, which is that environment matters, and sometimes the environment of maybe a court may not be conducive to the kind of matters that private parties want to do. I've had the privilege, not once, not twice, in which we've had to take a room. In fact, one in recent times before the COVID lockdown was at the Radisson Blu, where we took a meeting room for 1 week. The parties will pay. If the kind of things they're doing are of such matters, they will pay. It gives them their privacy. And it's not that they didn't want to be seen, because every day they were having lunch in the dining room and everybody saw them together having lunch there. It doesn't matter. So we have to understand one thing. We need to understand the value chain. To go back to this issue also of education of lawyers, it is very important that even we as lawyers, I'm very sorry, I don't mean to be disrespectful of my colleagues, but because many of us became lawyers before we became mediators, we ourselves have a problem dealing with our own mentality. We ourselves have to deal with ourselves and disabuse our minds from litigation. Let me make a suggestion. I am of the candid opinion that mediation, you cannot be an advocate, an arbitrator, and a mediator. Many people disagree with me, but I'm telling you this, that you cannot be successful. It's either you are bringing too much of a mediation mindset into your arbitration, or you're bringing too much of an arbitration mindset into your mediation. Mediation is a total ball game. It's different. It's a total mindset. And I believe that we need to begin to address that mindset. Lastly, let me say this very quickly, because yesterday I was speaking on this same issue. You see, litigation is like the World Wrestling Federation tournament. Litigation is a battle, is a combat. The lawyers are the gladiators. May the better man win. Even when in litigation you are speaking about give or take, the truth is that the stronger negotiator is the one who wins. The lawyer who's trying to be a bit soft and trying to be nice ends up losing. The eagle lawyers, the eagles, are the ones who win. So right from the time many of us even go into school, we are conditioned from law school that you have to be aggressive as a lawyer. I sometimes laugh when I see some young lawyers come to me and they pick up the phone, and I put on the phone a bit, and I said, can we talk? You don't have to shout to make your point. but it's not his fault. He has been taught, he feels that is part of his game as a lawyer. He has to intimidate the opponent, and when you now bring him to a situation where you say, well, no, that's not how it is. It's inconsistent with what he knows. One last point, so that I don't unduly, but I want to emphasize once again this issue of what is called authentic mediation. That is one thing I've been promoting recently. Authentic mediation. Authentic mediation. Mediation, with all due respect, ladies and gentlemen, brothers and sisters, dear colleagues, mediation is a unique thing. It's not akin to arbitration. It's not akin to litigation. It's a thing that has to be learned in itself. That's number one. Number two, we have to create the environment ourselves. Many of us mediators are not doing enough to educate the public and our constituency about mediation. It's not just about settling quarrels. It's an attitude, it's a frame of mind, it's a culture. And lastly, we have to understand that, therefore, when we have understood it, even lawyers, many of us have bad experiences with lawyers in mediation. But I've hardly had issues with lawyers in mediation. And many times I found that I'm able to do so 85% of the time because I put my hand around them. And many times within the process of mediation, I am leading them on. While they think they're using me, I end up using them. And they end up becoming useful to me. But even then, I have met one or two, in fact, the ubiquitous SAN. I had a matter last year, July, that involved two major oil service companies. I won't mention the names of the companies, but I always say that I left that place with a new respect for the SAN who represented one of them. He was extremely useful to me. He had such a mindset of mediation. I couldn't believe whether he stole the SAN or whether he won it in the normal way. I mean, it was such a delight to me. He became my paddy in that process. And it's a matter of understanding. I think we have to understand that mediation is not a legal process only. We have a lot of work ourselves to do in the mediation. We have to promote our profession. We have to fight it. We have to go out. We have to write books, write articles. We need to hold town hall meetings. We need to educate the public. We need to go into the universities, go into our alma maters, go and allow them to talk to the students at the university level. Like my brother Benjamin said, right in year one, when they're doing their orientation into first year law school, there should be mediators talking to them about mediation. They should be looking at it. When I was in university 47 years ago, we were taught ADR, arbitration, in third year university. It was taught. I'm saying to myself, if I had to influence that curriculum today, I would not just do arbitration. I would do mediation as well. But it's not done. Can we influence such things? That's the point I'm saying. And that, I rest my case.
Excellent. Wow. So very quickly, for the benefit of lawyers listening, because if money is not the value chain for lawyers, then what is the value chain for? So what's the value chain for a lawyer, and what is the value chain for an end user? What isn't money for a lawyer? What then is the value chain for a lawyer?
No, Fola, with the greatest respect, I think you have misused the term.
Okay.
Money is not the value chain.
Okay.
Value chain is not money. Let me give you a simplistic, highly exaggerated example of what value chain is. Good. Let me even use one that we're familiar with. Lawyers now, because litigation became something where we sit in court for 5 years, 7 years, what did they do? They introduced the concept of appearance fees. When I came out of law school years ago, people didn't have appearance fees. We did not have appearance fees. Why did appearance fees begin? Because of numerous adjournments and the costs of it. So people recognized the value there. Now, let me do a quick summary course. What is value chain in mediation? Number one, sometimes you have to spend time with parties. There's one thing that Nigerian lawyers are not very used to, and that is charging for your time. I spent some time talking to two parties, both based in South Korea. And when I began to speak to them, we had the first conversation. The second conversation, I said, gentlemen, as from now, I want you to know that beginning at this conversation, I am putting you on time. This is my charge per hour. Are you comfortable with it? They said yes. I have spoken to others who said, no, and I've closed it there. You see, that's part of the value chain. That's one. Your time, the time you spend giving that counsel, giving that opinion. Number two, contrary to what many people think, to be an effective mediator, you need to understand the subject matter. Sometimes you need to go and study it. You need to research it. You need to go into the things that are behind it. You need to read documents. You need to get evidence. You need to have people tell you things. Tell me what goes on. How did you do this? How did you do that? You need to, and that time you are spending doing that research is time. Time is money. Are you charging for it? Number three, you're sitting down in a mediation. Every time I sit down in mediation as a mediator, whatever it is, I learned this once when I tried to get a London mediator to do a matter for me, and said to me, well, this my charges, I charge X pounds per session, a minimum of 6 hours. Beyond the first 6 hours, I charge so much. And as a matter of practice, I expect a deposit of so much to cover a minimum of 2.5 sessions. If we do more at the end of the second session, I will invoice for them. Very clear. We need to begin to understand that there's a value chain. Now, what is the value chain? You're looking at every point along the trend of conversation where you're adding value, analyzing issues. Many mediators don't know that it is really the mediator who should help parties to identify the issues. You don't leave it to them. You're not just begging them to settle. You need to help them to identify the issues. That is value you are adding to it. You're adding to them. There is a cost to that. There's a cost to that. And so if we go on and on, like I said, what I'm saying is extremely simplistic and is more complex than what I'm saying. But there is a value chain. We have to understand the value chain. But we also have to understand some of the principles behind mediation, and that is what I call the value proposition. What are the things we offer in mediation? It's informality. Oh, I pray sincerely that we never lose that informality, that we never begin to write 1,000 articles like ICC chambers of arbitration for their arbitration rules. No, I'm hoping that we retain our informality. Number two, I'm hoping to be able to say to people, well, mediation is inexpensive.
Yeah. Sorry, sir. Informality or flexibility?
Well,
I think he means the lack of rigidity.
Yeah, but that would be flexibility now, not informality. I don't know what. Yes.
Well, okay, flexibility. But I said what informality means. For example, you don't have to address me as Your Honor or Your Majesty, whatever it is. That's what I mean by informality.
Okay.
Okay. And then we say it is inexpensive, and we say it is time saving, and it preserves relationships. You know, these are things that this is the value proposition, and you're able to say to them, we can do this. We can offer you this. You can get this. That is a value proposition. Most mediators don't know. Most mediators are not able to articulate that value proposition. We have to begin to train ourselves in developing that value proposition. We need to begin to also, now I want to say something, and if I offend, let me apologize in advance, but I can't help feeling that sometimes even mediators themselves feel inferior to arbitrators and law and barristers. If there's any measure in you at all, I want to encourage you, get out of it. I don't feel intimidated by arbitrators or whatever it is. It doesn't matter. An arbitrator may make $10 million in one matter that takes them 2 years to finish, and I could do 10 matters in the same period and get 1 million per case. We are earning the same thing. I don't feel inferior to anybody.
Yes, I saw it. But at the risk of putting you at the risk of putting you on the spot, sir, you have used 2 words that I feel in a way respectfully does not exactly even help us. Now, you use the word informal. In terms of context, I would probably use the word maybe flexible. Use the word cheaper. In context, I would probably use the word more affordable.
No, I never used cheap. I said inexpensive.
Inexpensive.
He said inexpensive.
Okay, but even at inexpensive still denotes a level of something that is cheap. I don't know, but
no. With all due respect, so let me tell you this: inexpensive. In fact, this is my normal way of speaking. I'll say it is inexpensive, not cheap. Now,
yes.
It is inexpensive, not cheap. Now, when you say affordable, what is affordable? What is affordable to Dangote?
It's relative.
What is affordable to Dangote? What's affordable to me? What's affordable to you? No, it's not affordable. It's inexpensive. It's cost effective.
Yes.
Okay. Cost effective.
All right. It's cost effective. It's cost effective. And one of the things that you do also in working mediation, a good mediator must know how to do two things. You must know how to do a cost benefit analysis, because when you are counseling your clients, you must be able to show them the cost benefit analysis and why it may pay them. It's part of reality testing in a more advanced stage. Now, most mediators don't know how to do this. They don't learn these things. They just say it saves you money. How? You must know how to analyze bottom line. You must be able to show people how mediation or non-mediation could impact the bottom line. You need to be able to show that. It's part of the skills we have as mediators. You see, as mediators, we need to continually build up our skills and learn and learn and learn and learn and learn. And if we don't, then it will become another legal thing. And God help us. Already we've been hearing about, earlier this evening, we're discussing about people already challenging mediators' confidentiality, challenging mediators being called to think. This is what I call lawyers playing their game again. They're trying to hijack it.
The process.
And I tell you that we have to resist it. Oh, I'm a lawyer, yes, but I'm a mediator now. We need to resist it. Don't let them hijack it. I will do all I can to prevent them from doing so. That's what they want to do. They did that with arbitration. When I did arbitration for the first time in my life, I sat in the office of the arbitrator in Western House with a tray of tea and biscuits. I tell this story all the time. Between myself and the other arbitrator and the other lawyer on the other side, in front of Nylander, who was the arbitrator then, we were having an arbitration. Most arbitrations worldwide tended to be that informal. Only the most complex cases, especially cases that involved sovereign states, went into that highly formal arbitration. But what is happening today now? There was a small matter we were holding at LMDC during the settlement week, and when they would not settle and they now decided to go to arbitration, the first thing the arbitrator told them, they should go and deposit 36 million naira. They called me up and said, can we do the mediation now? I said, I'm already out of the matter. You'll have to go back to LMDC. But you see, that is what arbitration, with all due respect, has become. And that's why many people are running into arbitration. And just like, with all due respect, there are many persons today who are SANs who, with the greatest of respect I can have, maybe have no business being SANs. There are many arbitrators who chose arbitration because there is money in arbitration. No, and there have some who have refused mediation because there is no money there. But I tell you, how do you define money? How do you define money? Well, gentlemen,
ladies. Your question has raised. Somebody sent me a question, and she would want to remain anonymous. She says that, Fola, please ask Mr. Kisoya to articulate these concepts of value chain and value proposition into writing soon. That's number one. And flowing from that, she says that, again, can we address the fact that mediation is open-ended? If a mediation does not settle, what impact would that have on the value chain?
I will set up a webinar for which a fee will be charged, and she'll be informed.
Okay, noted. Thank you, sir. Yeah, I mean,
that's the value chain. That's the value chain we're talking about.
I like that, sir. I like that. I like that. Duly noted. Yeah, Abby. I think we had some hands raised up. I don't know whether you want to speak. Okay, I think Mr. Okay, Mrs. Evelyn. Those, Mr. Evelyn, before you speak, Miss Rev Doc has just been dropping emojis, laughing, and Rev Doc, do you want to say anything? You have been dropping emojis. Do you want to say something? Do you want to give a voice to those emojis? Before I take Mrs. Evelyn. Okay then, Mrs. Evelyn, over to you. We can't hear you.
I think Ayejide was saying that the client, that is the respondent or the applicant, they need to be educated, and some of them, they don't respond. Actually, it's a fact, because when we started, it was very difficult for them to come to court. When you serve them, they will say they will not come. Some will even say, over my dead body, I don't want to settle. But after some training from Milord Ariman, I think there was really enough changes in bringing them to court. We have to educate them. Actually, we were using bailiff to serve. Those bailiff, they go there with the approach they use in serving for litigation. It was very wrong. But we have to pick up the pieces. We have to do the service ourselves. When we go there to serve, we go there not to fight or to force them to come to court. We educate them. We will tell them the reason why they are coming. And we also tell them some of the benefits and what they will be expecting. So we'll find out that they were responding, and we don't actually have problem in them coming to court anymore. So they themselves, just as Ayedide have said, they themselves, they need to be educated. But we can't go to we can't just be educating them, educating people we can't see. Or should we be going for radio, televisions to educate the public concerning mediation? This will take a very long process. Actually, when we serve them, we meet them one-on-one, we talk to them face to face. And some of them will just, okay, fine, I'll come, but I was thinking that is a litigation. I just want to go and take my lawyer. I want to go and take my lawyer. We now find out that some of them, they find it very easy to approach mediation because they find out that it's a place where they can talk, they can express what is in their mind, and they can get their settlement be done. And it's not a place where they will fight, neither look at both parties as if they want to kill each other. It's a place where two of them can come together and actually resolve their problem. So it really works that way. So that was the suggestion I want to bring in. If it's possible for the lawyer themselves or for the mediator themselves to do the service themselves and try to talk to them so that they can approach mediation.
Okay.
Fola, please, can I say something very quickly? I know that Rev Doc wants to say something which I'm itching to hear. Apart from the CEDA accreditation process, which many of us went through, I also enrolled in a course with the Abilene Christian University on mediation, and one of the things I want to corroborate what Evelyn is saying, especially with mediations. The thing is that actually in the process advocated by the Abilene Christian University, the part of the mediator's job actually involves approaching the parties individually and introducing them. Do you get it? So I agree with you. A court bailiff arrives and serves you a mediation process. Yeah, I'm going to call your lawyer. I mean, but especially with private mediations, somebody speaks to you first. And when you've spoken to them, they've said, well, this is the person I have a problem with. And you actually call that other party and say to them that, well, this matter is on, would they like to go into mediation? You've been approached by this person to carry out mediation. Now they could say no. They could say no. I'll do mediation, but I don't trust you. Who are you, and so on and so forth. And part of the job of the mediator is actually to help the parties become comfortable with the process. And I believe that I just wanted to say this quickly because I think what Evelyn was saying was so right. If somebody arrives in my house as a big court bailiff and gives me paper of mediation, I will not do. I will first of all call my lawyer and I will say, you see, it creates a different approach than when, in fact, LMDC used to do it a lot in the past. I don't know whether the present administration still do it, but usually when parties it's actually the director of the LMDC who calls the parties, or the chairman of the governing council who calls the parties. It makes a lot of difference than to get the call from a case manager or get the call from a court clerk or a court registrar. But when the director or a member of the governing council calls them, especially when they're high up persons, it makes a lot of difference because it is all part of this process of creating the right environment from the beginning. So I agree with Evelyn totally. I just wanted to corroborate the point she made.
Okay, thanks so much. Yeah, Abby, before we take Web Doc, is there anything you want to say? Abby? Okay, Web Doc.
Yeah, Fola, I totally agree with Evelyn and Mr. Akinsoya on their submission on counsel. In the last 2 months, I've gone through, I think, possibly the worst mediation in my career. A very high value case between two very high value Nigerians, almost running to $10 million. And it has a mediation and arbitration clause. The counsel from the beginning on both sides refused to let the parties attend mediation, that I will have to mediate with them. After 3 meetings with the counsel, the respondent served the claimant notice of arbitration and said that the mediator is too slow. It was very funny because, when you don't want to descend into the fray. So I was mediating the counsels, I was mediating the parties, I was mediating the dispute. It was a nightmare for me. Eventually, I got the parties to the table. And when I asked for a caucus, the parties said, their lawyer said they must not have a caucus with me. I said, but that's part of mediation. The lawyer said, objection. There's a constitutional right for legal counsel to be present when parties are meeting with anybody, that I cannot meet with them. I said, but that's what I told you at the beginning in the opening statement, and you signed the agreement. He said, well, it's ultra virus, and in fact, I don't know, I've never heard of it before. I think you are lying. That was what hurt me the most. I think you are lying about caucus. Nobody has the right to order private meetings. I have to be very smiling and gentle. It was a nightmare for La. Eventually, we settled. We've signed the agreements, we've done the affidavits, we've closed the mediation. But I've not healed. I was called a liar. I feel like calling the counsel and saying to him, why do you do this? But I have to just move on. But I'm just sharing today because, yes, the counsels are terrible, but you have to get the job done. I didn't take it personal. I didn't talk to him. I mean, he lost his dad in between the process. I called him. I communicated with him. I took a 1 week adjournment. We did everything properly. But I am very hot. I'm not a liar. And private meetings are part of mediation. I know that. But I'm trying to ask him to go and do the training and pay for him. But it was terrible. He served notice of arbitration 3 times without copying me to the other party. That look, let's move on to arbitration. This man is wasting time. And I just felt, we are in mediation. I will close it. I'm meeting with parties. I'm getting the issues out. You guys you have gone to police, you have done everything for the last 2 years. I'm trying to understand this matter. I just came into this matter barely 2 weeks ago. And, it was as if everything I said, the councillors were like, no. When we want to go to arbitration, you're wasting our time. This is not working. And I'm like, if you go to arbitration, I didn't want to start saying, you won't get this decision in a day or two now. And you won't be free. But we settled anyway. We settled. We signed all the agreements. We've gone before the court to file the NMDC as a consent judgment. I've done everything. But it was very traumatizing. The council attacked me personally. There is nothing like caucus in mediation. I don't know where that came from. I don't know where that came from. Senior counsel.
I think that came from a place of feeling he felt like he was not going to be in control. As Mr. Akison had said earlier, power, lawyers have the power. In a mediation, lawyers don't have the power.
Sorry, may I say something because Rev Doc is someone that, first of all, I have a lot of respect for, and because I know his personality, I feel he's hurt. That he should be addressed that way. But one thing I found also, though, and this is my personal opinion here, when parties are represented by their counsel, in fact, I always insist that if I'm going to be in caucus with the parties, I want their counsel to be present. And I tell the lawyers that. And surprisingly, sometimes some of the lawyers will say to me that, no, I need you to be there.
No.
And sometimes I think, without being unduly patronizing, the kind of thing the man talked about, that it is constitutional right, I actually tell them that, look, it's your constitutional right to be represented by counsel in any matter. But this is not, you see, the thing that I've found here is that if you work with the lawyers, especially the very senior lawyers, you need to sometimes you need to treat them like, I don't want to use any word, but you have to kind of put your hand around them. I always insist that if lawyers are present in my introduction, and my introductions can be rather lengthy because I take the time to explain to everybody, including the lawyers, what I think their role should be and how I want them to assist the process and what kind of assistance I'll look to them. And I often say to them, and if you ever think I'm going out of place, you have a duty to your client to call me to order. And the moment I throw the power to them like that, they can't be aggressive toward me any longer because you've thrown it to them. So that way, immediately I found that in 8.5 out of 10 times, it immediately calms them. Because I'm saying to you, I recognize your position. I understand you are here. You have a job to do. Look, these are the basic differences between a mediation and a court action. This is so. I don't even like to say this is party-driven, because when you say party-driven, they raise their daggers. What are you saying? Are you trying to get my client to? Are you trying to? People become what's called. People become defensive. And so you want to avoid that. But let me stop there. I understand how Rev Doc must feel. And some of those lawyers can make you feel that way. But my attitude is, if you know they're going to be that way, then don't let it surprise you. That's my attitude. I go in expecting the worst from them. And at the end of the day, we end up being friends. 9 out of 10 times, there's still the one that won't work. Thank you. I think I've spoken enough today, Fola.
Fola, that's where I got that word from. Throughout this session, I was referred to as honorable mediator, and the sessions were called tribunal sittings. Despite my several correction, honorable mediator, the tribunal will meet. I'm like, there's no tribunal here. Well,
so I think it boils down to the knowledge, if you ask me.
Knowledge.
Yeah,
honestly.
It boils down to the knowledge and the mindset. It's just that mindset. And I think in our defense, It just has to do with how we were schooled. In law school, being taught to be advocates, being taught to be gladiators. So there has to be, so for me, I think mediation really for every lawyer is not even about learning. It's more about unlearning. There are so many things that we have been taught that we just need to unlearn. Unlearning and relearning rather than learning. So it's been a beautiful, beautiful session today, interactive. We've been able to learn a lot from all the seasoned mediators and arbitrators we have here thus far. And we're supposed to have Milord today, but we couldn't. So we'll probably be taking her sometime in October. So I will not be having a mediation session next week. We'll definitely be back upper week. Thank you everyone for tuning in, and I'm wishing everyone a lovely week ahead. Thank you so much, everyone.
Thank you.
Thank you.
Bye.
Thank
Everyone. Bye. Okay.